cool way to start on that. We can start, I guess, with ZADIAN PROSZEK. This folder might give data. PROSZEK. Wow. But
all right, I think we're ready to begin our afternoon court calendar. We'll do that by calling the case of the state versus ZADIAN PROSZEK, case 25 CM 2965. Appearances, please.
ADA Sam Smith for the state.
ZADIAN PROSZEK appears in person and in custody, represented specially by attorney Will Anderson of the Public Defender's Office. Has received a copy of the criminal complaint. We would waive its formal reading. Ask the court to enter not guilty, please. We probably need to give a new address, just one moment.
And Commissioner, just so you're aware, the public safety assessment on Mr. PROSZEK was just printed out within the last couple of minutes.
Okay, thank you, Mr. Rogers. I appreciate that.
All right. Understand. I don't have a updated address for Mr. PROSZEK at the moment, so let's leave what's there. I can say that he has applied for a public defender and been deemed eligible in this matter. Thank you.
All right, I appreciate that update. The booking sheet says that he is also being held on an extradition claim from Winona County, Minnesota. Before I deal with the lawyer's recommendations, I think there may have been a victim logged in who wanted to be heard regarding bail in this case. If that person could unmute their microphone and then share their thoughts, that would be fine.
Hi, yeah, I'm Julian. I'm Zayden's partner. I just want what's best for him, and if he's able to go to some kind of mental health facility or rehab, I'd like the courts to consider that as well.
All right, I appreciate that information. Thank you.
Thank you.
You're welcome. State's position on bail.
State's recommending cash bail in the amount of $500, along with the condition that the defendant make no acts or threats of violence towards Julian W. Reason for the cash, some things that we've already alluded to here. I believe the defendant is on probation out of Waukesha County in that case in Minnesota. The open case, I believe it was in Winona County, Minnesota. He is only 19 years old. For those reasons, the state feels cash is appropriate.
Okay, Mr. Anderson.
Thank you, Commissioner. We would be asking the court to issue a signature bond in this case with the non-monetary conditions as suggested by the state. Primary one being no acts or threats of violence towards the victim in this case. As we discussed briefly earlier, Mr. PROSZEK is on extradition hold for Minnesota. I noted in the criminal complaint that it was stated at least that he had been released from prison relatively recently. So I wonder if the hold may be related to that perhaps. Either way, I think if $500 of cash would be beyond his means, we are looking at misdemeanor allegations here. Ultimately, we've got a victim who's supportive of Mr. PROSZEK being able to move his cases forwards. I think based on what I'm seeing on the bail sheet here, he's currently homeless, not working. He's telling me the $500 would keep him in custody, would also prevent that extradition matter from moving forwards. Looking at all of that, I think this is appropriate case for signature. All right. He was homeless until recently. I suppose he is living, if he is released back into the Madison community, he does have a place to stay. That would be with the person who spoke earlier today.
All right. The PSA recommends cash bail. I assume that's got, or that has more to do with the nature of the charge being a battery than it does a significant failure to appear history, because that same report doesn't really list much of a history with failure to appear. I think this would probably be a pretty workable signature bond case, if not for the claim that he's wanted in another state. With that, the state's request is quite reasonable. I'll set cash bail at $500 with the condition that he not engage in any acts or threats of violence towards Julian W. We'll get a not guilty plea entered. I think what that means is that if he posts and is able to get released once the extradition thing is cleaned up, there wouldn't be a legal prohibition on him returning as described earlier. It would just be with the obvious rule that there couldn't be threats or acts of violence. Good luck to you, Mr. PROSZEK, and thank you, Julian, also for being here.
Thank you.
You're welcome. Bye-bye. I think Mr. Gilbert is now here too, so. Are you ready? Okay, yeah, let's call the case of the state versus Anthony Gilbert, case 25 CF 2830. Appearances, please.
Sam Smith for the state.
Anthony Gilbert appears via Zoom video teleconference from the Iowa County Jail. Here in the courtroom is attorney Will Anderson of the Public Defender's Office. I'm representing Mr. Gilbert for today's purposes. Have you received a copy of the criminal complaint in this Dane County matter, Mr. Gilbert?
I think he's on mute.
Could you indicate with a thumbs up if you have seen that document? Thumbs down. Okay.
And Mr. Anderson, I think the state might have a motion that would help resolve that issue.
Okay.
At this time, the state's moving to dismiss this complaint.
No objection.
All right, so and I don't know whether you wish to make any additional record as to reasons.
No.
Okay, well, Mr. Gilbert, sounds like the state's willing to dismiss the complaint anyway. I'll grant that request. I'll dismiss the case without prejudice. 2 thumbs up from Mr. Gilbert in response to that, and I certainly recognize where he's coming from there. Mr. Gilbert, good luck to you. Take care.
Brandon DISRUD.
All right, we'll call the case of the state versus Brandon DISRUD, case 25 CF 2693. Appearances, please.
ADA Sam Smith for the state.
Brandon DISRUD appears in person and in custody, represented specially by attorney Will Anderson of the Public Defender's Office. He's received a copy of the criminal complaint and would waive its formal reading. Okay. The address on the complaint on County Road C is the correct address for him moving forwards. And I have a note here that he has applied for and is eligible for a public defender in this case. Thank you.
Thank you. Mr. DISRUD was brought here by writ from Dodge Correctional. I believe that he is represented by Attorney Chung. Attorney Chung did try to communicate with us late last week that Mr. DISRUD would have preferred to have appeared remotely or some way other than coming back and forth physically. I think that would have made a lot of sense too, Mr. DISRUD. Unfortunately, I think the wheels were already turning on getting you here by the time that happened. To my knowledge, there's no reason to assign this to any specific Dane County judge, so I think we can just let the computer pick that. Does the state have any position on bail?
State's recommending a signature bond and a ban from Fleet Farm.
No objection to a signature bond.
All right, I'll order a signature bond with the ban from any Fleet Farm location. Let's put on a preliminary hearing right away since he's here, and then that's consistent with the language in the writ too.
And that's what Attorney Chung requested as well. We can talk to Kathy. Okay, she can take care of that. We're not gonna do that right now. So I'll let her know I can go back. I'll tell her to come see me tomorrow or something, talk about it. But for now, they'll get it on, okay?
Yep, we'll get it scheduled right away. Good luck to you, Mr. Disrupt. Take care.
Next will be Jonathan Britton.
All right, we'll call the case of the state versus Jonathan Britton. It's case 25 CF 2846. Appearances, please.
Sam Smith for the state.
Jonathan Britton appears in person and in custody, represented specially by attorney Will Anderson of the Public Defender's Office. Has received a copy of the criminal complaint. Will waive its formal reading. Do you want to change your name and address to the jail? The address on the criminal complaint is a good address for him moving forwards. And I have a note here that he has applied for and been deemed eligible for a public defender in this matter.
All right, thank you. My booking sheet says that he is on a hold. I should look to find out if there's a specific branch to assign the case to. One moment, please. Okay, the clerk advises that hold stems from a conviction in branch 11. So by local court rule, we'll get this case assigned to the same judge, Judge Burrs. State of position on bail?
State's recommending cash bail in the amount of $250,000, along with the condition that the defendants not possess any dangerous weapons if released. In support of the substantial cash bail the state's requesting, I'll note what's alleged in the complaint is a very dangerous situation. I'll note Mr. Britton is a felon, I believe was on probation. What's being alleged here by the state is that there was an argument over some driving behavior in a parking lot that escalated or turned into a shooting. It's important to note that the victim in this case was shot in the back of the head, and Mr. Britton at the time was prohibited from even having a gun. So for those reasons and the obvious reason of the large amount of prison exposure, I think $250,000 is appropriate.
Mr. Anderson?
Thank you, Commissioner. May I have a moment to speak to Mr. Britton off the record?
Of course.
Thank you, Commissioner. We will be requesting less cash than what the state has requested. We believe $100,000 would be the appropriate amount here. That's still obviously a extremely large amount of money, and I don't think Mr. Britton or his family would have that money available anytime soon. But it is potentially a more attainable number for him. As ADA Smith noted, he is on probation and will be on a supervision hold here for the foreseeable future. Beyond that, I think I'll leave it up to the court. We're just looking at for a number that might be more within reason if he were to muster all of the resources available to him. Thank you.
Your Honor, if I may be heard, there's something I neglected to include, and certainly the defense can respond if they'd like. There is a victim in this matter who doesn't want to be heard, but wants their wishes read into the record. So if I may do that.
Of course.
Victim feels strongly that the defendant should get significant cash bail in the amount of $1 million. That victim also requests the defendant not have any type of contact with any minors. She feels given Mr. Britton's criminal history involving children and the detrimental impact of the crime that this crime has had on the victim's children, that he should not have the right to be around minors. I'm still maintaining my original request, but I wanted to read the victim's wishes into the record, so thank you.
Sure, and I think it's fair then that Mr. Anderson have any opportunity to reply.
But I just don't see anything in here, in the criminal complaint here that relates to minors, so that would be a condition we would object to. Other than that, I think we're talking about large amounts of cash bail here regardless, and we still feel that 100,000 would be an appropriate amount. Thank you.
So this is an Act 3 eligible offense, which means I'm supposed to consider the totality of the circumstances. I'm supposed to include among those circumstances, prior convictions for violent crimes, appearance risk, the need to protect the community, the risk of witness or victim intimidation, as well as consideration of any affirmative defenses. In terms of prior violent crimes, the complaint alleges that he was convicted 5 months before this of substantial battery. He's on supervision for that substantial battery. The complaint further alleges a child abuse conviction 14 years ago, a number of years ago. I should actually look to see whether that technically counts as an Act 3 prior. It does. It may be that that's where the victim representative is getting the information about children from. I'm not sure. Because I agree, this complaint itself doesn't really make reference to anything child related that I can see. But the point I make is that there are prior violent offenses, and that's what I can glean from the criminal complaint. I don't know whether there are additionals. As far as appearance risk, neither parties presented information suggesting a history of non-appearance. However, Mr. Britton is alleged to have shot somebody. He's facing crimes that carry somewhere around 75 or 80 years of potential incarceration if there's a conviction. I'm expressing it in that fashion because there's a number of enhancers and modifiers, and I didn't go do the math specifically, but just the core crimes themselves would be 70 years of potential exposure. There's an obvious community safety issue when somebody's getting shot. And then there's the risk of witness intimidation. I don't know if that's as strong a factor here. I of course, don't know much about the dynamics of this situation other than what's been described here on the record and what's in the complaint. The community safety aspect is not, is not a minor point here. It's a pretty substantial point given the nature of the charge and the type of injury and location on the body described by the state. I am supposed to consider potential affirmative defenses, and I recognize that when I review a criminal complaint, it contains an account of the circumstances. This is an account that appears to be supported by video evidence. It isn't necessarily the whole story or the other version or something from each perspective, and I recognize that. I can imagine in what sounds to be maybe a road rage type situation where the complaint describes two parties retreating behind vehicles where there could be the possibility of an affirmative defense. There are some that certainly come to mind, and I don't ignore that. I think that that's an appropriate consideration. This is a long-winded way, though, of saying that my role is to make sure that the community is safe and that Mr. Britton is present so that he can have his day in court and the state can have its day in court and there can be some resolution of these charges. I'm not willing to set bail on this at anything less than $300,000. I'll set it at that number. I'll order that he not go armed with dangerous weapons. I'll order that he not have any contact with any immediate family member of JMW. I'm going to decline to set the minor condition. I guess I agree with the defense that I don't see that that's specifically tied to what's alleged in this complaint. I understand perhaps the broader context of that, but I'm supposed to set bail conditions here that are related to what's alleged in the complaint and are necessary in response to that. And I'm not sure I'm seeing that at this particular point. Mr. Britton's entitled to a preliminary hearing within the next 10 days. I assume we should put that on right away.
Please, Commissioner.
All right, we'll do that. And of course, bail can be reviewed at that too if there's a proper motion filed. Right now with the probation hold, there really isn't, he's not bailable in any event, as I think Mr. Britton probably knows. Good luck to you, sir. Take care.
Commissioner, did you adopt the weapons? Okay, thank you.
Next to GERALD Parks. Parks.
All right, we'll call the cases of the state versus GERALD Parks. Their cases 25 CF 2838 and 25 CT 829. Appearances, please.
ADA Sam Smith for the state.
Gerald Parks appears in person and in custody, represented specially by attorney Will Anderson of the Public Defender's Office. He's received a copy of both criminal complaints. We would waive their formal reading, ask the court to enter not guilty pleas to the misdemeanors. The address on the criminal complaint, is that a good address?
Yes.
It is a good address for him moving forwards, and I have a note that he has applied for and been deemed eligible for a public defender in these matters. Thank you.
Thank you. The booking sheet says that he is on an ES hold. Looks like that stems from a branch 5 case. So we'll get this case assigned to Judge McNamara as well. Or these cases, I should say. Does the state have a position regarding bail?
In 25 CF 2838, the state's requesting $1,000 cash, along with the conditions that the defendant not operate a motor vehicle, that he not consume or possess alcohol. Reason for the $1,000 request, it looks like the defendant's now facing his 8th OWI, which carries a mandatory prison sentence. I believe he's on probation for his 7th OWI. He has a lifetime driver's license revocation, so I think the blanket no operating condition is appropriate. As to 25 CT 829, state's recommending a signature bond in that he not operate a motor vehicle.
And I recognize one's a misdemeanor operating after rev charge, and the other one's a more serious felony charge, but I'm having a little trouble reconciling those recommendations.
The reason for the 2 separate recommendations is exactly what you mentioned, Commissioner. One of them is an OAR, and another is a charge that carries a mandatory prison sentence. So I think the cash bond requested in that case reflects the potential exposure. Whereas the signature bond for the OAR case is appropriate, but I defer to the court if you want to set different amounts, but that's the state's request.
Okay, thank you.
And I got an attorney come Thursday, just so you know. You're not stuck with me.
Oh, sure.
What's that? Well, I don't know. I'm kind of torn there, because I just stopped there. Then I start there when he said today. Right? Or like 2 weeks ago. You get credit for all that.
Commissioner, I would just point out that I would argue for a signature bond in this case. I'd point out that Mr. Parks is on a probation hold, and so the bail situation is likely not going to control his release from custody. I note on the application for a public defender that he is on a fixed income through Social Security of just over $1,000 per month. So I think $1,000 of cash bail would be prohibitive for him. He also, as he just pointed out to me, is a lifelong Madison resident. I don't have any information about missed court appearances. It's not an Act 3 eligible offense, so we would request signature bonds in both cases. Thank you.
Any response from the state?
No, thank you.
Not sure I'm following either of these recommendations, but I need to take just a little bit closer look at the complaint and the recent history before I make a decision about that. I'll also give each party an opportunity to add anything more before I finalize anything.
I understand.
Yeah. No, it's wait for bail another day. It's very true.
I'm looking at the most recent conviction, the one from 2022. It's very similar. I think it's actually the same arresting deputy. No, it wasn't. Okay. Well, in any event, it was similarly like a .07 OWI case, but it would have resulted in the mandatory minimum 3 years of incarceration. Either lawyer have anything you want to add about this?
No,
About that, if you wish, but just more generally about the bail here.
No, Commissioner, thank you.
4.05. That matters.
And I'll repeat that because I think that was a good observation that Mr.
Absolutely.
Parks made. That the reported alcohol concentration in this new case was a 0.05. Yeah, and I think it's a fair point. It's fair to recognize that it's a level that wouldn't necessarily be legal or a per se violation of the prohibited alcohol concentration laws for most drivers.
Not impaired either.
That would be an issue that would have to get resolved, I suppose, at a trial based on physical manifestations and the like, and probably expert testimony, but I get the point you're making, Mr. Parks. The difference though between Mr. Parks and most drivers is that most drivers don't have 7 prior convictions for operating under the influence. They're not subject to a special rule created by the state legislature that says that they're really allowed almost no alcohol while driving, that their level has to be below a 0.02. In Mr. Parks's case, it's alleged that he really shouldn't be driving a car or a vehicle at all because he doesn't have a driver's license and doesn't have a present ability to get one. Certainly the alcohol levels that are in this complaint are not the sort of shocking kind of alcohol levels we see in a lot of complaints. And I recognize that. I don't ignore that entirely. I also don't think I should ignore the fact that he's on extended supervision for allegedly doing basically the exact same thing for which he got the mandatory minimum prison sentence. There's a good reason to think that the same thing would result here. There's a concern about Mr. Parks's willingness to comply with the rules in terms of driving and or drinking if he were to be released. I also don't think I should ignore that one of the complaints here is a totally separate driving after revocation case. Again, I don't want to take what is in most situations not the most serious offense and make it something much bigger. The trouble is Mr. Parks is not in the same position as somebody who has 1 prior conviction or gets their license revoked for some other reason. I don't think I should adopt either of these recommendations. I'm not going to go substantially higher than what the state recommended, but I'm not willing to set bail on these amounts. On the misdemeanor case, I'll set bail at $500. Again, this isn't substantially bigger, and as long as the hold's in place, it probably doesn't make as much practical difference anyway, but the least I'd be willing to set on the felony case is $2,000 cash bail. In each case, I'll order that he not operate a motor vehicle. In the felony case, there'll be a condition that he not consume alcohol, and then we'll get the misdemeanor case sent on to the assigned judge. The felony case should get scheduled for a prelim right away, and I assume that's his request.
Yes, please.
Okay, we'll do that. Mr. Parks, I do hope things improve for you. Good luck to you.
All right, that's great. Mr. Parks. Next up is MAURO CORTEZ-FLOREZ. Bail hearing. CORTEZ-FLOREZ.
Buenas tardes, ¿cuál es el final?
All right, we will call the case. Actually, cases of the state of Wisconsin versus MAURO CORTEZ-FLOREZ. Cases 25 CF 2076 and 25 CF 2847. Appearances, please.
Sam Smith for the state.
MAURO CORTEZ-FLOREZ appears in person and in custody, represented specially by Attorney Will Anderson of the Public Defender's Office. He has received a copy of the new criminal complaint, would waive its formal reading. And if I may just speak to him for one moment.
Sure.
The address on that criminal complaint of 2016 Pike Drive, Apartment 3 is the correct address for him moving forwards. And I have a note that he has applied for and been deemed eligible for a public defender in this matter. Thank you.
Certified interpreter Femi Filipiak is here. Ma'am, do you swear or affirm that you will truthfully and accurately interpret the proceedings?
I do.
Thank you. In case 2076, we're here on return of a bench warrant that was issued after a missed status conference on November 10th. At that time, a $750 cash bail was forfeited. That case is assigned to Judge Burrs for trial purposes, which means we also need to assign the new case, case 2847, to that same judge. Does the state have a position regarding bail in these cases?
As to the case for initial appearance, it's 25 CF 2847. State's requesting $750 cash, with the condition that the defendant not consume or possess alcohol. I'll note that this was the amount set in his previous case. I'll also note a failure to appear on November 10th of this year. As to the bail hearing for the case ending in 2076, the state is requesting $1,000 cash, along with the reinstatement of the non-monetary conditions. It appears $750 was set on September 12th. And as I mentioned earlier, the defendant failed to appear on November 10th.
Thank you. Mr. Anderson?
May I have a brief moment to speak to Mr. Cortez-Flores off the record?
Absolutely.
Yeah. They were supposed to call me on the phone because it's telephone. Tend to change the date to the 15th. So I came on the 19th and then he told me it's not always a telephone. So we ran back out to like the argument home, but no phone calls. There'd be a lot more things in one. At 26, I also came.
Pero me como hacía mucho ayer se me voló el papel y cuando llegué aquí no pude comunicarme a explicar como pues.
And what happened was the paper blew away, so by the time I got to the paper was able to explain to them. No, I was like,
So ya se subí el segundo piso y dijo que iba
the second floor was a. In fact, I'm not so sure. I didn't find anyone on the computer.
Okay, thank you, Commissioner. This is a bit of a difficult situation. Since I am working through an interpreter, I did have a moment to speak to Mr. Cortez-Flores about the missed court appearance. He tells me that he actually did go to the courthouse that day. And there must have been some sort of miscommunication between himself and the court staff. Because he was told that he was scheduled for a telephone hearing and to expect a telephone call. I do note that he was without counsel at that time. And he tells me as well that he then returned to the courthouse on November 26th because he was told that that was the day for his court appearance. And he talked to numerous different people in the courthouse, but ultimately no one could find him or his case in the system. So there is clearly some confusion here. I would note then there would have been the judgment of forfeiture just very, very recently. So given that the cash was already forfeited and had already been set at $750, I would ask that the court reset cash bail in that case at $750. As we're looking at a standalone bail jumping in the new case, I would ask that the court set bail at less than what the state has requested. $250, I believe, would bring the total bail to $1,000, more than what was set when it was posted previously. I have notes here that Mr. Cortez-Flores has been living in Dane County for 5 years, but is currently unemployed. So the $1,000 would represent a significant amount of cash. Taking him at his word that he did make efforts to come to court. We do have a large backlog in terms of getting folks appointed attorneys at the public defender's office. That may have contributed here as well. Thank you.
If it helps, I'll note that he did have a scheduled telephone hearing in a separate family case, case 19 FA 383 on November 19th. So that could be in the mix there somewhere as well. Any response from the state?
I have no information from my office about a phone appearance. And regardless of whether he has assigned counsel, it's up to the defendant to know his court dates and times.
I certainly agree with that last point. At the same time, I suppose if there's a lawyer assigned to the case, that's another person that can help provide reminders of court dates or check in with somebody prior to the court, which itself serves as something of a reminder. So I can see where that has some benefits. I'm not aware of a substantial history of failure to appear on Mr. Cortez's part. I think that the defense position is fairly reasonable on this. I'll adopt it. I'll set $750 cash bail in case 2076. That one has conditions that he not have contact with Elizabeth L.G., that he not be in the 4600 block of Thurston Lane in the city of Fitchburg, and that he not possess or consume alcohol. In 2847, I'll set cash bail at $250 with, again, the condition that he not possess or consume alcohol. That number is less than what I would typically set on a felony charge where there's a bail violation alleged. But recognize that it's only part of the picture because he would also have to post the bail in that other case. And was required to post that other cash bail relatively recently. I think this is still a pretty substantial bail result, but I think it balances things appropriately. We'll get not guilty pleas entered on any misdemeanor charges. What should we do with the time limits regarding prelim, Mr. Anderson?
If I may speak to him for just one moment.
Sure, and he had previously waived the time limits in the earlier case.
Okay.
So.
It's the case that no one was, she said she didn't want anything to do with it. So for kids.
If we could just have it set for a timely preliminary hearing, Commissioner.
Sure, we'll schedule both right away. Take care, sir.
Thank you.
That would be Darren Hargrove.
Let's call the cases of the state of Wisconsin versus Darren Hargrove, cases 21 CF 2226, 23 CF 1201, and 25 CF 360. Appearances, please.
ADA Sam Smith for the state.
And Darren Hargrove appears in person and in custody, represented specially by Attorney Will Anderson of the Public Defender's Office. He has received a copy of the most recent criminal complaint for which his initial appearance would waive its formal reading, asks the court to enter a not guilty plea to the misdemeanor. And let me just, do you receive mail at this end? Where do you want me to? If we could please update his address, mailing address on all cases to the Beacon at 615 East Washington Avenue in Madison. And I have a note that he has applied for and been deemed eligible for a public defender in these cases. Thank you.
All right, thank you. So in 21 CF 2226 and 23 CF 1201, we're here on return of warrants. They were issued by Judge Conway back in March of 2024 after a missed court appearance in those two cases. Because of the rotation system, my understanding is that those cases are being reassigned to Judge Burrs in Branch 11. Normally, Branch 11 would hear its own bench warrant return hearings, but in this case, they specifically asked us to do that. And that's great. It gets Mr. Hargrove into court to have bail addressed on them sooner rather than later. In both those cases, it looks like Judge Conway forfeited a $250 cash bail after the most recent non-appearance. That's a really long way of also explaining that in the new case, 25 CF 360, we have to get that case assigned to Judge Burrs so that they're assigned consistently. Does the state have a position regarding bail on any of these cases?
In the new case, 25 CF 360, the state's recommending cash bail in the amount of $2,000. Commissioner, you went through a lot of the history of the defendant's cases, but just for the purposes of my bail argument, I'm going to touch on a few different things. As you mentioned, the defendant had or has two, now three pending cases. He's missed court on March 11th, 2024. Across those two older cases, he missed court on, I believe, July 13th, 2023, January 13th, 2023, and an IA way back November 1st of 2021. I'm also asking in this case for conditions to include no contact with Isabella M. That's ISABELLA. And a ban from the 6200 block of Schroeder Road in Madison. I think $2,000 cash is appropriate for the reasons that I mentioned previously. And in the two bail hearing cases, because of the failures to appear and the warrant status, the amounts of time in warrant status, I'm asking for $500 per case and the reinstatement of the non-monetary conditions. Thank you.
I'm sorry, I missed the last cash request in the old cases.
For the two bail hearings, $500 and the reinstatement of non-monetary conditions. For the new IA case, $2,000.
If you need to take a moment.
May I have a moment to speak to Mr. Hargrove?
Sure.
Thank you, Commissioner. Hold on just one moment, Mr. Hargrove. Thank you, Commissioner. After speaking with Mr. Hargrove, I would request that the court reimpose the $250 cash in the two cases for which we're having a bail hearing today and set bail in the case for which we're having an initial appearance at $500. That would bring the total amount of cash bail to $1,000. Based on my conversation with Mr. Hargrove, that would be an amount of money that he thinks is well beyond his means at this point. He hasn't worked since 2022. He is essentially homeless at this time. And what it sounds like, I asked him why he was in warrant status for this length of time, going back to 2024. And it sounds like there was some miscommunication between himself and his attorney as to where the cases were headed. And he thought the cases were on a path to dismissal. Obviously, he needs to keep better track of what's going on with his cases, but I think these are very dated matters. He is having some trouble even kind of remembering what was going on in his life back at these times. Ultimately, he was just hired for a job. He is homeless, and if he is held in custody on the amount of cash bail, or frankly, even the lower amount that I'm requesting, could jeopardize his ability to keep that job. So for all of those reasons, we're asking that the court consider less cash than what's been requested, a total of $1,000 across the three cases. Thank you.
All right, thank you. I'm gonna set a total cash bail equal to what the state requested, but I am gonna structure it a little bit differently. I'm gonna set cash bail in each of the three cases at $1,000. And I'm doing that because while all three cases are different, they each have their own sort of level of seriousness, or I should say they're each serious in their own separate way. In 21 CF 2226, he's charged with uttering a forgery, a felony charge, though certainly not violent or assaultive in nature. The trouble in that case is there is an extensive failure to appear history. The case is about to enter its 6th calendar year since charging, which itself is about a year after when the alleged crime occurred. It's probably not a big mystery that it would get to be harder and harder to remember things. That's, I guess, understandable when the case is dragged on as long as it has. Sometimes, I mean, this is a case where maybe even some of the delays are attributable to the pandemic. It's been so long. But there's also the extensive failure to appear history in the case to boot. In case 1201, there's an allegation of flight and running from the police and things like that, which goes right to the heart of likelihood of failure to appear. And of course, we know that it's almost been 2 years since when the warrant was issued by the judge in that case. And then we have the newer case, 25 CF 360, which naturally doesn't share the same problems with a history of failure to appear or aging, but is itself a serious charge. It's not assaultive in the physical sense, but it's yeah, I guess invasive and something that would reasonably cause somebody to be in fear. I think I have to take into account somebody who's alleged to be a victim in that case and their desire to perhaps get the case put behind them sooner rather than later. The history with Mr. Hargrove suggests that that's unlikely without a little bit more substantial bail. So I'm going to set the $1,000 in each case. I'll continue any previously imposed conditions in the old cases. In the new one, I'll order that he not have contact with Isabella M. and that he not be in the 6200 block of Schrader Road. He's entitled to a prelim within 10 days on that case. I assume we should get that scheduled right away.
Please.
Yeah, we'll do that. I want to just confirm that he's passed prelim on the others. I think he is, but I'm going to check. Yeah. He is past prelim on the others. I see. I was getting thrown off by a docket entry that was not 100% accurate, but we'll deal with that later. Mr. Hargrove, we're going to get you set up with the court dates here. The bad news is you're still having to deal with all this. The good news is you're this much closer now to getting it dealt with and getting it put behind you. That would be good for all of us. Good luck to you.
Okay, we're coming up.
Thanks. Next is Paris Minge or Mingy, forfeiture.
This is the best way to pronounce your last name.
Mitch. Yeah, y'all said it
Just
right
like it
the
was.
first time.
Okay, very good. Well, let's call the case of Dane County versus Paris Minge, case 25 FO 2475. Appearances, please.
ADA Sam Smith for the county, the defendants here in person in custody without counsel.
Okay, so Mr. Minge, some good news. It looks like the police brought you to jail. There was the possibility of, or was the possibility of a criminal charge or two. The DA's office has decided not to charge you with a criminal offense.
Okay.
They have charged you with a forfeiture. It's kind of a fancy way of saying that it's a ticket for resisting or obstructing an officer.
Yes,
So a non-criminal charge. One option is to enter a not guilty plea to that. If you enter a not guilty plea, we're going to let you out of jail without you having to post a bail. You'll just get another court date that would keep open your right to have a trial on the charge, to look into your options a little bit more fully after today, maybe even hire a lawyer if you wanted to. So that's all one option. Sometimes people really want to get the case just resolved here today. And if so, the county may have an offer for a fine to resolve it here. Do you want to hear an offer from them, or do you prefer to just enter the not guilty plea for now?
I know.
Okay,
That'd be to resolve this for court costs only.
so it would wind up being $114.50 if you took that offer.
How soon I have to pay it?
You'd have 60 days unless they set up a longer payment plan through the clerk's office. You'd get out today either way.
Let's knock it up.
You want to get, okay, very good. I'll take that as a no contest plea. Yeah, I see you shaking your head. Yes, very good. I'll accept the no contest plea to this non-criminal charge. I'll find you guilty of it. It's the $114.50. We're gonna give you a little reminder envelope here in the next room.
Okay.
Take care to you. Take care. Good luck to you.
All right.
Bye-bye.
Next up will be, okay.
Next is JOHNNELL BRITT.
All right, we'll call the case of the state versus JOHNNELL BRITT. It's case number 25 CF 2841. Appearances, please.
ADA Sam Smith for the state.
John L. Britt appears in person and in custody, represented specially by attorney Will Anderson of the Public Defender's Office. Has received a copy of the criminal complaint, would waive its formal reading, ask the court to enter not guilty plea to the misdemeanor. The address on the criminal complaint is a good mailing address for him moving forwards. And then I have a note that he has applied for and been deemed eligible for a public defender in this matter. Thank you.
All right, thank you. The booking sheet says that he is also being held on a federal supervised release violation or an allegation of a violation of that. State of a position regarding bail.
State's recommending cash bail in the amount of $2,000, along with the conditions that the defendant not possess any dangerous weapons and that he have no contact with Matthew H. Reason for the cash, I'll note, disorderly conduct while armed is an Act 3 eligible crime by virtue of the dangerous weapon enhancer. And I think based on what's alleged here, just particularly concerning conduct of someone who's willing, allegedly, I understand at this point, but someone who's willing to pull a firearm on someone for simply asking him not to pee in a parking lot. I think cash bail is appropriate.
And Mr. Anderson.
Thank you, Commissioner. We would be asking for a signature bond in this case. I'm looking at the public safety assessment that was prepared and filed. It does recommend a signature bond. I note no failures to appear at all for Mr. Britt, despite having prior sentence to incarceration and believe in federal court from what we're hearing. So he does seem to have a good appearance history. The issue then, more than anything, would be the Act 3 eligibility. I'm not sure that this offense rises to the level of requiring cash bail, especially when he is subject to that federal supervision hold that Your Honor mentioned earlier. So for those reasons, I would ask that the court consider a signature bond for Mr. Britt. Thank you.
All right, and if either of the lawyers knows and wants to weigh in, this is fine, but otherwise, Mr. Rogers probably knows what the federal offense is that he's on supervision for. Mr. Rogers, can you hear me?
Yes, Your Honor.
Yes, Mr. Rogers, in Mr. Britt's case, do you have information about what the prior felony conviction, or I'm sorry, well, yes, it would probably be a felony conviction also, but what the prior federal conviction is for?
I do not. One of my colleagues did this one. I can look it up, but I'll need just a second.
Your Honor, Mr. Britt is telling me it's for armed robbery.
Okay,
Just robbery.
that's all right, Mr. Rogers, I think we have
Excuse
the
me.
answer.
He corrected himself to robbery, not armed robbery.
Fair enough, okay,
Yep, thank you, Your Honor.
sure, thank you all. And counsel, anything more before I figure out what to do here?
Nothing to add from the state.
No, thank you.
Okay, I'm going to adopt the state's recommendation. It's concerning that he has a prior state, I think it says armed robbery conviction, then apparently a separate federal robbery conviction. There's the alleged possession of a firearm in the presence of some drug-related items as well, though it's not 100% clear from this complaint whether those are intent to deliver type quantities or just regular user quantities. It seems like the sort of case that would be it would not be surprising if there were a federal indictment in response to it also. The state's request is pretty reasonable under the circumstances. I'll adopt the $2,000 cash bail recommendation. He can't go armed with dangerous weapons or have contact with Matthew H. As you're probably aware, Mr. Britt, until the feds deal with your supervised release hold, you really can't go anywhere either way. But I hope things improve for you. Should we put on a prelim right away on this charge?
I suppose so. Yes, thank you.
Yeah, we'll do that. All right, good luck to you.
Next is Emily MATHYS, forfeiture complaint.
All right, we'll call the case of Dane County versus Emily Mathis, case 25 FO 2471. Appearances, please.
ADA Sam Smith for the county, defendants here in person in custody without counsel.
All right, and just to confirm, your is it Mathis?
Matthews, sir.
Matthews, thank you.
Yes.
So it looks like the DA's office has decided not to charge you with a criminal offense for what they're saying happened on December 7th,
Okay.
2025. They have charged you with an ordinance violation instead for disorderly conduct. So it's like a ticket for disorderly.
Okay.
You could enter a not guilty plea to that charge. If you enter the not guilty plea, you'll be able to be released without having to post any kind of bail. That would keep open your right to have a trial on the charge, or maybe consult with a lawyer, or just more fully look into your options before making decisions. The other option is that the county probably has some offer for a fine to just resolve it today too, if you're interested in that. Either way, I think you're walking out of here because it looks like your state corrections agent has lifted the hold.
Yes, sir.
Yeah. If you're not sure, a not guilty plea is kind of the safer answer.
Can I go not to guilty here?
Sure.
Thank you.
And should we be adding an apartment J to this address on the complaint?
No, that is where I was from the complaint, but now I'm going back to a sober living place
Okay.
due to my PO and just to move out from that situation.
So is there a better address for us to use?
Yes, 26 North Hancock Street, Madison, and then that's the 53703.
All right, we'll get it updated. We'll get the not guilty plea entered. We'll get you some paperwork here in the next room. I hope things work out for you.
Thank you, sir.
You're welcome. Take care.
Actually, Julie CRUZ.
Okay, we'll call the case of the state versus Julie CRUZ. It's case 25 CM 2647. Appearances, please.
ADA Sam Smith for the state.
Julie CRUZ appears in person and in custody, represented specially by attorney Will Anderson of the Public Defender's Office. This is an initial appearance, yes, Commissioner? Or-
It is. It's a case that was initiated with a complaint and a warrant.
Got it. Okay. I had a note here that it's bail hearing. I just want to make sure that's incorrect. Well, she has received a copy of the criminal complaint, would waive its formal reading, and would ask the court to enter a not guilty plea. Just looks like the address is a good address for her. Okay, for about mail or about something? Okay, give me 1 moment then. Let's get through this all in the appearance. Okay. One second. And I have a note that she has applied for and been eligible for a public defender. Thank you.
All right, thank you. So, as we talked about earlier, this is a case where it's not that Ms. CRUZ missed court. It was started with a warrant. But she is on a probation hold. Looks like that comes from a Sauk County case. I think we can just have the computer randomly pick the judge here in Dane County assigned to this one. Let's see if the state has a position on bail.
State's recommending a signature bond and a ban from all Woodman stores.
No objection, Your Honor.
Seems reasonable. Let's do a signature bond with that condition. We'll get a not guilty plea entered. Ms. CRUZ, means you have a signature bond on these charges. You're still gonna have to deal with your agent as far as the whole, but that's between you and the agent, okay?
So since you don't have anything holding in South County Jail, your agent will keep you here until she decides what to do with you. You would
Even though
not.
it's a sub.
Correct.
That's
Because you were arrested in Dane County, okay? All right.
You're all set.
Good luck.
Good luck. You're welcome.
She was arrested.
All right, we'll call the case of the state versus Michelle Kern, case 25 CF 2848. Appearances, please.
Sam Smith for the state.
Michelle Kern appears in person and in custody, represented specially by attorney Will Anderson of the State Public Defender's Office. She received a copy of the criminal complaint and would waive its formal reading. Ask the court to enter not guilty pleas to, there are no misdemeanors, excuse me. And the address on the criminal complaint of Norma Road in McFarland is a correct address for her moving forwards. She does not at this time qualify for a public defender.
All right, we should talk a little more about that. So they're saying you make either too much money or have too many assets to have a public defender right now. You're always free to contact them again if your income changes or you just want them to recheck the number. You could hire a lawyer on your own. You could represent yourself. Sometimes people make too much money for the public defender, but not really enough to hire somebody on their own. If you think you're caught in between like that, there's a process for applying through the clerk of court's office. Sometimes they can help you advance you a lawyer with a payment plan. You're in good hands for today. You're covered. He'll help you today either way. What's the state's position regarding bail?
State's recommending a signature bond along with the conditions that the defendant not operate a motor vehicle without a valid driver's license and not operate a motor vehicle with any alcohol in her system.
No objection, Your Honor, unless you need to hear something from us, we can move forwards.
The only thing I wonder is if I should just make the alcohol condition be a blanket no alcohol requirement, essentially an absolute sobriety requirement, rather than tying it to driving. But I'm open to suggestion on that by either party.
All right. I just spoke to Ms. Karen about it. She's planning to put herself into treatment here. I know just reviewing her record that has been quite some time since her last OWI, so I think this was a bit of a eye-opening experience for her. So no objection to an overall ban on alcohol consumption while she's dealing with this case, Your Honor.
Any objection from the state?
No.
Okay. I think it's a better recipe for success here. Let's do a signature bond with conditions that she not drive without a valid driver's license. And also that there just be no consumption of alcohol. We'll get a not guilty plea entered on any misdemeanor charges. What about the time limits for that next court date, Mr. Anderson?
Let me just speak to her briefly. So next court. Okay, she would like to waive the time limits for the preliminary hearing and set a status conference, Commissioner.
That sounds great, and I wish you well with everything. Take care.
Good luck.
That's the Crystal Lee.
We'll call the cases of the state versus Crystal Lee, cases 25 CF 2842, 2843, and 2849 through 2853. Appearances, please.
ADA Sam Smith for the state.
Crystal Lee appears in person and in custody, represented specially by attorney Will Anderson of the Public Defender's Office. She's received copies of all of the criminal complaints, would waive their formal reading, and ask the court to enter not guilty pleas to all of the misdemeanors. And the address on those complaints in Marshall, Wisconsin is a good mailing address for her moving forwards. And I have a note that she has applied for and been deemed eligible for a public defender in all these matters. Thank you.
All right, thank you. Advise that the co-defendant has open cases in front of Judge Condar, which means by local court rule, we would have to assign these cases to Judge Condar as well. Does the state have a position regarding bail?
Yes, and I'll go through the non-monetaries on each case that I'm requesting. For clarity, I'm requesting $500 cash per case. Starting with 25 CF 2842, requesting a ban from Dick's Sporting Goods, Ulta Beauty, and a ban from Old Navy. Also, no contact with the co-defendant in that case, Shamira Stacy. As to the case ending in 2843, a ban from Ulta Beauty and a ban from Sephora. Again, no contact with Shamira Stacy. As for the case ending in 2849, a ban from Kohl's. As for the case ending in 2850, again, a ban from Kohl's. Two 2851, again, a ban from Kohl's. 2852, a ban from Kohl's and Sephora. And lastly, 25 CF 2853. A ban from all Sephora stores and no contact with the co-defendants. One is Shamira Stacy, the other being India Cole.
For the clerk's benefit, I think Cole in this case is spelled C-O-L-E. Did you want to be heard regarding the reasons?
As far as reason for the cash in each of these cases, I suppose it can be, we can all tell based on the incident dates, but this is in a relatively short time. It looks like a month-long crime spree, stealing thousands of dollars worth of merchandise. And I understand how, in my short experience, how these cases normally resolve. I know they're retail theft, so there's nothing violent here necessarily, but I think when you take them all together, all of the potential incarceration time, if convicted, creates an incentive to not come to court. So I think $500 per case is appropriate.
Mr. Anderson?
May I have a moment to speak to Mr. Lee?
Of course.
Well, Commissioner, this is a tough one. Obviously, we have a bunch of cases in front of us here, but we also have somebody who has no open cases, and there are no bail jumpings charged in any of these. Is innocent until proven guilty, obviously. A public safety assessment suggesting that she should receive signature bonds in these cases. So I do want to ask that the court consider signature bonds in these cases. Failing that, I would ask that the court impose an amount of bail that totals no more than $250, because that's the amount that Ms. Lee tells us that she would have the ability to post. Any other amount is going to hold her in custody. She suggests, I think the primary concern here would be future criminal behavior, bail violations, engaging in additional retail thefts while she's out on bail. Because I do know that in the one case she had resolved through the court system. She was good at coming to court. I spoke to her prior attorney earlier today. They're already in touch about getting Ms. Chung appointed to represent Ms. Lee in these cases. And Attorney Chung tells me that Ms. Lee was always good about communication and good about coming to court. I note on the PSA that there have been no failures to appear. So these aren't Act 3 eligible cases. Someone's been good about coming to court. The issue is that she's being charged with a lot of crimes at once. And they seem to span several months, however, and she'll have to review each and every one of them to see, you know, where the evidence, the strength of the state's case in each of these. I understand that there are other people involved, and that a lot of this is going to come down to video. Ms. Lee, as is noted in at least one of the complaints, she is a mother. She has 2 young children who she has custody and guardianship of. They live with her. She does have her own apartment in Marshall, Wisconsin, that she would be at risk of losing if she is kept in custody. And she was recently informed just prior to coming into custody that she's pregnant. And so she needs to seek medical attention for that. She's also on prescription medication that she's been unable to access since she has been brought in here to the jail. As I said earlier, she does qualify for a public defender in these matters. She's currently attending the school, but not working. And so the amount of cash bail that has been requested by the state, which I believe would total $3,500, is prohibitive for Ms. Lee by far. And while acknowledging that it is a situation where there are all of a sudden a lot of open cases, this is someone who has always come to court in the past, and I believe should be given the opportunity to show that she can come to court again as she resolves these matters. She did say that she would be willing to go on an ankle monitor. I know that that would be GPS monitoring through pretrial services. The way the conditions were requested, I'm not sure that a geographic ban from these stores would be practicable, but I do note many of them occurred at the malls, so it might be possible to ban her from the Easttown and Westtown Mall and to enforce that condition using GPS, if that was a way of finding a way to lower cash bail that Ms. Lee could potentially afford to post to secure her release. Thank you.
Any response from the state?
I'll just note, I agree with a lot of things that Attorney Anderson mentioned, but I think, and again, I'll acknowledge these are retail thefts and who knows how these are going to resolve, but we have someone here who has, I believe by my counts, 7 open cases, and I think cash bail is appropriate. Thank you.
I'm just reading one section of one of the complaints a little bit closer to make sure I'm understanding it correctly. So what's sort of, and you kind of made reference to this a little bit, Mr. Anderson, but I didn't think through the detail of it a whole lot as you were saying it. What sort of geographic restrictions do you think would work as part of a GPS?
Well, what occurred to me would be a ban from the Easttown and Westtown malls. I think that would cover most of the stores, maybe not all, but most. That's what I suggest. I don't know if we have an area map set up for that or if pretrial services has ever enforced that kind of ban. I feel like I've had it in another case of mine, but that's just kind of going off memory.
I'm sort of torn here because there are arguments to be made on both sides, and maybe even more so than in any case. Here's my struggle, and I'll just maybe lay it out there and see whether either council has a response to it, and maybe it'll sort of inform Ms. Lee's wishes as to how I deal with this from a bail perspective. I don't see this as a situation where she would walk out of here on a straight signature bond or on a total cash bail along the lines of what she suggested, like $250 without some very, very, very strict restrictions on her ability to go places. These complaints they're certainly nonviolent in nature. They're property crimes. That is all true. but they involve organized group activity with multiple other individuals that are as prolific, as occurring at many different types of retail stores, not alleged to be like the stealing of food or alcohol or something where there would be a sort of a physical compulsion for it. They're mostly high-end luxury goods that suggests that there is some ability to turn goods into money and have access to money to post bail. It also, just the prolific nature of it, I think, suggests that some cash bail is appropriate. I also do read one of the paragraphs in the complaint in case 2843 to suggest that she was cooperative in her apprehension. That one paragraph sort of suggests that there was a telephone conversation and there was an arrangement made for her to figure out some arrangement for the kids and stuff before the police would pick her up, and then she was there and went with the program. And I think that's to her credit. That makes a difference here, I think, to some extent. I shouldn't say to some extent, it makes a lot of difference. You know, if instead of it saying that in this complaint, it said, she was fighting with the police or running or wasn't there or something, the numbers that the state is talking about would probably be ones where they'd have to work pretty hard to convince me to only go that low. But Ms. Lee does, this complaint does say that Ms. Lee was cooperative with that part of the process, and that's something. I don't know that Easttown and Westtown Mall as a sole ban area is sufficient, because I don't know that all of the locations fall there, and I'm also a little bit concerned about the risk that just shifts the location. I wouldn't say that if this were a one-off retail theft alleged to have occurred at some particular store, but there's just so much. I guess what I'm inclined to do is either to set some sort of a cash bail that would total really, frankly, between the numbers that have been proposed by either of the parties and go along with the specific stores that have been requested as bans, or alternatively consider pretrial services with GPS monitoring. But we'd be talking about something pretty close to home confinement, I think, if there's the benefit of a signature bond and we're taking a chance on pretrial services and all that. There obviously could be exceptions for showing up in court and meeting with legal counsel and doctor's appointments and that kind of stuff, but that's sort of the gist of what I'm considering. So I'll sort of show my hand in that way and see if either lawyer has any thoughts in response to that.
The state has nothing more to add, Your Honor.
If I could just speak to Ms. Lee for a
Yeah,
moment.
please.
Thank you, Commissioner. I did have a chance to speak to Ms. Lee. She would prefer, if given the choice, which is somewhat being discussed here, to be on monitoring, even if with stringent conditions. Her particular concern at this point is that she has paid for a non-refundable reservation for a birthday party for her daughter who's turning 5. She hopes that she would be able to attend that even while on GPS monitoring.
Yeah, I didn't mean to cut you off.
No. And beyond that, Your Honor, I was just saying, when I said Easttown and Westtown Mall, I was going off memory, and I think I understand your concern that would just shift the location. I do think Hilldale and then Coles Monona were kind of the two, as well as maybe Coles Easttown. But I would leave it up to Your Honor to fashion whatever in GPS conditions you think might be effective here. She would prefer that over cash. She would be unable to post much over $250. Thank you.
Okay. And I'm trying to think of how best to deal with this issue of the kid's birthday party. I'm fine with it in concept. I'm just,
Right.
We do live stream the proceedings, and I'm not sure that we want to invite the entire world to your child's birthday party by getting into the specifics of that over the live stream.
Sure.
Maybe you could get like the date and the place and that and communicate it with writing about it so that. Well, I guess I could just silence that part of it too. I'm gonna make an executive decision that this is an issue that is not really worthy of being like. All right, so we did have a very brief discussion that identified the date, place and time of the child's birthday party. What I'll do is in each of the cases, then I'll order signature bonds. I will order as conditions that she has to report to pretrial services no later than 10 a.m. tomorrow morning. So you're gonna be able to get out today. But so, yep, the deputy, good question. The deputy's gonna hand you a sheet here that describes where to go. It's over at the courthouse. They're gonna connect you with a GPS device. That GPS device is going to make sure that you're complying with the conditions of bond. Those conditions in each case are gonna be that you not be outside of your residence unless you're going directly to or from scheduled employment, to or from court proceedings, scheduled meetings with a lawyer or scheduled medical appointments. There will also be an exception for the birthday party. And I'm not sharing the details of that right now out loud for the reasons we talked about earlier, but the clerk has that information and we'll make sure that it's in the minutes so that you're protected in that way. So I don't have a problem with you going to your child's birthday party. That's a good pro-social thing. That's something that is important to you. I think it's important to me that you be able to do that and go there and get that done. Certainly important to your child. Also important to your child is to make sure that when you get out of here, you report the pretrial services and you don't put yourself in a position where we have to revisit bail in these cases. You did the right thing by being cooperative with the cops on whatever night this was, a couple of nights ago. That's the start of moving forward with this thing and getting it dealt with. Don't pick up more charges, don't have contact with those people, and you'll work your way through this. You're in some trouble, but you can deal with it. It's just gonna be an issue of you not having that trouble snowball further.
For sure, you were talking all over the no contacts and banner requests at the bottom.
They're essentially redundant, but I suppose so, yeah. I suppose we should adopt those specifically as well. Thank you for asking that. And then, what about the timing of the preliminary hearings? I'm sorry. I mean, I was actually asking the lawyer.
No, that's fine.
You're good.
Let's keep those intact. I know that Attorney Chung will be appointed shortly.
Okay.
Thank you.
We'll get them scheduled within the next 20 days then. So Ms. Lee, you'll be able to get out of here today. I hope this works for you. Yeah, take care of yourself. Good luck to
Put
you.
an ankle monitor on you that's gonna require you to be in your house unless.
That's tonight.
No,
tomorrow.
Tomorrow, before 10, go to their office in the courthouse. Okay, okay.
Thank you.
Good luck. I'll tell Kathy what happens.
JOHNNELL Shores, is a horse, so I'm for you.
All right, we'll call the case of Dane County versus JOHNNELL Shores, case 25 FO 2472. Appearances, please.
ADA Sam Smith for the county.
And are you JOHNNELL Shores?
Yes.
Okay, so it looks like the DA decided not to charge you with any criminal offenses for what they're saying happened a couple days ago. They have charged you with an ordinance violation, so it's like getting a ticket instead of a criminal charge. In this case, it is for resisting or obstructing an officer. So you have some options. One option is to enter a not guilty plea to that. If you enter a not guilty plea, you'll be able to be released today. You won't have to post a bail. It would keep open all of your rights, including having a trial, maybe talking to a lawyer, or just looking into the thing a little bit more before having to make decisions. The other option is that if you're pretty sure you want to just resolve this today, they likely have some sort of an offer for a fine to do that. Again, it's not a criminal charge. Do you want to hear an offer from them or do you prefer that not guilty plea?
Where is my lawyer?
Well, there is no lawyer here to represent you because you were not charged with a criminal charge. This is the sort of charge where you'd wind up hiring a lawyer on your own if you're,
Alright,
yeah.
so if I pay not guilty, then what?
I'm sorry, ask that
If
again.
I pay,
Yeah.
play not guilty, then what?
If you enter a not guilty plea, then we write that down, we get you another court date and you're released from jail. If you take their
So
offer,
I
you're gonna
get
get out of
released?
jail today too. Either way,
So I give a piece?
you're gonna get released either way.
Okay, so not guilty.
Fair enough. We'll get the not guilty plea entered for you. We're gonna get you another court date here in the next room. Good luck to you.
Thank you.
You're welcome. Take care.
Everybody's got-
Everything that's smooth with this.